Welcome to this video on murder. Now, murder is a topic found on paper 1 in criminal law for both the OCR and the AQA syllabuses for A-level law. So to start at the beginning, the questions we need to be able to know or answer on murder are: what is the definition of murder? What's the actus reus of murder? How do you prove a defendant caused a murder? What's the mens rea of murder? And once we're comfortable with all of this, we'll be able to apply the law to a problem question. Now, this will be covered in a different video if you search for how to apply the law on murder. An overview then, we're going to look at the definition of murder, we're going to look at the actus reus, including causation, we're going to look at the mens rea of murder, and we're going to look at the sentencing as well. So of course we start at the beginning, the definition of murder. So murder, first of all, is a common law offence, which means it's not defined by an act of parliament. It's been defined on decisions by judges, which is known as case law or precedent. Now, the accepted definition is based on one given by Lord Coke, but simplified by Lord Taylor in 1997. So this is the one you should use to frame your responses. The definition is that murder is the unlawful killing of a reasonable person and being, and under the King's or Queen's peace, with malice aforethought, express or implied. So there's quite a lot to unpick there, and so what we will do is go through this definition and consider what each element means, starting with the unlawful killing. So for the actus reus, then, we need to look at unlawful killing of a reasonable person and being under the King's or Queen's peace, with malice aforethought. Now those first three form the actus reus of a crime, and malice aforethought form the mens rea of murder. So the full definition then: on a charge of murder, the prosecution have to prove that the defendant did a deliberate act, that the act was unlawful, and that it was a substantial cause of the death of a person and being. That's the actus reus of murder, and the mens rea is at the time of the act, the defendant intended either to kill or to cause really serious bodily injury to the victim, or subject to the extent of transfer malice to some other person. So it's quite wide ranging, and this gives us our overview again. So we've looked at the definition of murder, we're now going to focus on the actus reus. So the actus reus of murder considers quite a number of things. So unlawful, killing, human being, and Queen's peace. I'm going to address each of these in turn, beginning with what unlawful means. So when we consider when might killing a person be lawful, we need to consider a number of different things. What we're really asking is there any legal justification for the killing? Some legal justifications may be during times of war, for example, or they may be in the line of duty, subject to police officers and so on. It may be in self-defense, or of course medical treatment. So we're going to look at some key cases first. We're going to look at the Crown of Marchurek and the Crown of Steel. And here it was decided that if the victim has the life support machine turned off, then it's not going to be an unlawful killing. We'll also look later at the idea that this doesn't break the chain of causation. So Marchurek, when the defendant stabbed his wife, he was responsible for the death when the life support machine was turned off. So it does also discuss the idea of a person being legally brain dead or in a persistent vegetative state, and therefore makes the distinction that little bit clearer. In Re children, this is a case which concerned conjoined twins. Now, in this particular case, the doctors needed to separate the twins. They did know that had they separated the twins, the weaker twin would die, but the stronger one would survive. And again, so this was referred to the court, and the court suggested that it's not an unlawful killing because the doctor was acting in the self-defense of the stronger twin. So again, an idea where medical treatment or medical intervention will not be considered an unlawful killing. So now we dealt with unlawful, we need to consider what exactly is a killing. Okay, so the killing can then be either a direct or indirect act, or an omission where there's a duty. So what a direct act is the most obvious one, in which you would do something to bring about death. So Adams, for example, in this case the doctor was charged with easing the passing of his patients. In effect, he gave injections to hasten death. So bringing that death forward was a direct killing. However, if we contrast that with the harlot's case in Mackey, in which two indirect cases. So in the harlot's case, the defendant, a sex worker, left her baby under a pile of leaves, unattended. Now, during the period in which the baby is unattended, it comes to some harm, and as a result died. And in this case then, so what we got is an indirect act which caused the death. She didn't do a direct act. In Mackey, a bit more of an obvious example, the defendant in this case threatened his 3-year-old stepson with some severe thrashing, and the stepson ran away, scared. As he ran away, he fell down the stairs, tripped, broke his neck. Now at this point, again in court, they decided that this was an indirect act which caused the death. Now, we've done omissions in previous units, and certainly in the build-up to murder in criminal law, one of the underpinning elements of actus reus. Where a duty does exist then, if you fail in your duty and a person dies, then you can be guilty of murder. Such was the case in Gibbons and Proctor, where a 7-year-old was left to starve and died of malnutrition after she was failed to be taken care of by her dad and stepmom. Now a little note there as well is that causation must be proven. Now you may find this in different elements. You may do actus reus first, causation and mens rea. Some will, but this is the way I teach it to my students, and if you are one of my students then you could verify that. So if you like to pause this, you can always look at the cases that I've just mentioned there. And Mackey as an indirect, Adams as a direct, and Gibbons Proctor as an omission, and the harlot's case as an indirect act. So we're going to look then at omissions cases, because this is something in which you may need to do. In terms then of the images, they represent some duty of care. So this case, Greener and DPP represented a statutory duty, and in particular a statutory duty to muzzle a dog. The next image represents the case of Pitwood, and in this case the defendant had a contractual duty to act. The next one, Stone and Dobinson, and again this is a voluntary assumption of responsibility. Diadem in the police officer case, and this represents a duty because of an official position. And finally the case of Miller, in which you set in motion a dangerous chain of events. If you fail to do anything about them, then you can be legally responsible for the outcome. Now do note, not all of these concern murder, but they do is a recap of omissions cases and different types of duty which may occur. A case which certainly did concern death was the case of Victoria Climby as the victim, the case of the Crown and Kowal and Manning. Now in this particular case, the couple were convicted of murder for the great niece, the first defendant's great niece. She was 8 and she died of multiple organ failure caused by hypothermia and malnutrition. Now despite the fact she was abused physically in their care, the immediate cause of death was neglect rather than any positive act. So had the positive act killed her, then it would have been the direct act. However, in this case, there was a failure to care for her which killed her, and it was a deliberate failure. They did possess mens rea and were convicted of murder. Another case in which concerns medical treatment and the idea of failing to do something is Airedale Health Authority and Bland. Now this involved a young man who was badly ill at the Hillsborough disaster. Now this is one of the final victims, and what we have here is the victim was in a persistent vegetative state 18 months later, and the doctors wanted to discontinue artificial feeding so that he might die peacefully. Now the outcome of this case was that failing to feed them would not amount to murder, and this is because it's a medical case. In this particular case, Lord Goff said there's a distinction between, for example, in Adams, where an injection was given to hasten death, and in Airedale, where they might withdraw support because it's no longer in the best interests. So that will not be murder. Another point of killing then is that causation must be proven. Now this is not usually an issue, but there may be if there's more than one cause. So we need to always prove factual causation, legal causation, and also consider whether there is any new and intervening act. So a recap of factual causation is the but-for test. So in talking specifically about murder, we ask, but for the defendant's actions, would death have occurred? Now in white, the death wouldn't have occurred anyway because the poison in the mum's drink didn't kill the mum. She died of a heart attack before the poison could take effect. There was no factual causation, so not guilty of murder because she was already dead. In Paget, again, a classic illustration, the girlfriend was used as a human shield in the shootout with the police. In this case, factual causation was established, so before him holding his girlfriend as a human shield, she would not have died. Now in Dios, it was not established, because factual causation was not established, and this is because the victim was beaten by a group, and a brick was used at some point to hit the victim on the head, but two things can be proven, whether that was the blow that killed him, and also whether Dios himself used the brick. And so therefore factual causation couldn't be established evidentially, and he could not be guilty of murder. Cox, again, no satisfaction of the but-for test because the body had already been cremated, so again a lack of evidence meant that factual causation could not be established. And again, this was an injection of patient's case. In terms of legal causation then, so we have the key case of Kimsey, which tells us that the link needs to be more than a trifling link. You may also refer to this as the de minimis test, again illustrated in cases we've already looked at. So Paget, were the defendant's actions more than a minimal cause of the death or more than a trifling link of the death of his girlfriend? The answer is of course yes, so legal causation is established. In the harlot's case, we have a situation where the defendant was more than a trifling link despite not being the main cause of death. So it's important to know in scenarios, we're going to come to this in a different video, but in scenarios to establish were they more than a trifling link. So this is a legal question. But of course we need to then consider why might the chain be broken, or when might the chain be broken. Medical treatment, as we know, very rarely breaks the chain of causation. If the victim tries to escape, that might break the chain of causation, but not if it is foreseeable or reasonable. And then also we need to consider the thin skull rule. So an overview here, if you wish to take a screenshot or make notes of the correct cases for each point. Then with medical treatment, we know that very rarely breaks the chain of causation. We looked at Malchuk already, but we're going to look at the three key cases of Jordan, Smith and Cheshire. Now with the victim trying to escape, we looked at Mackey already, but we're going to look at Corbett too. We need to take into account the victim's condition and whether this is alters the rule slightly. This is the thin skull rule, Ruby and Woods, and the victim's beliefs in Blau and Holland. So in terms of medical treatment then, we know from Malchuk, switching off a life support machine will not break the chain of causation. In Jordan, the medical treatment was so bad that it became the cause of death. And this is because the original injuries had healed and the antibiotics were the cause of death. And so be careful when looking through scenarios, because this can be almost deliberately if somebody mentions antibiotics was the cause of death. Now that might not always break the chain. You need to look at whether the wound had healed first and then you can follow Jordan. Otherwise, it's likely you're going to follow Smith and Cheshire as authorities. In those two cases, despite the fact that the medical treatment was quite bad, it didn't break the chain, and so the original defendant was still responsible. If the victim tries to escape, so long as it's reasonable, the chain of causation won't be broken. So we looked at Mackey before in terms of escaping the stepfather, but Corbett is a case we're going to introduce here. So here the appellant chased Bishop down the middle of the road, and on catching him, punching him in the head and butted him. Another friend pulled the appellant off Bishop and held him back. Now Bishop ran off, tripped and landed in the gutter of the road. and he sat up but had his head protruding into the road. He was then hit by a passing car which killed him. Now, although this was not foreseeable in the truest sense, perhaps, the chain of causation was not broken because it was within the range of foreseeable range of events, given the circumstances and the intoxicated state the victim was in at the time. We also need to consider the victim's condition, and this might be the thin skull, where the thin skull rule applies. So in Ruby, the defendant gave a half-hearted kick to the head during a fight to the victim, but he had a thin skull and died from a kick to his head. Now, he was guilty of manslaughter because there was no mens rea present for murder, but it illustrates the rule that you can cause it and the chain will be broken if the victim possesses some physical peculiarity or weakness. Now, in Woods, again, despite the fact the jury acquitted in this case, it does discuss the law quite well. So essentially, a young man was left in charge of his younger brothers and sisters while a father was away at war. But when the father returned, he assumed that role or kept that role in some way. Now, one day he struck his brother for being cheeky. The brother got up, walked out of the room, but collapsed and died because he had a rare and unsuspected thymus condition, which made him highly susceptible to any sudden shock. Now, he was charged with manslaughter. There was definitely no mens rea for murder here, but again, it proves the point that if, certainly with the direction of the judge here, he should be guilty if he struck an unlawful blow, even though it wouldn't cause serious harm to anyone else. It shows us two things. Jury equity is alive and well, or at least was in this case, but that judges will direct as to the thin skull rule, and it won't break the chain of causation. So in terms of the victim's beliefs, one of the most famous cases is Blau, and again this will be studied when you do causation. In this particular case, the defendant stabbed the victim quite a number of times. Now, the victim could maybe have survived if she had a blood transfusion, but as it was contrary to her religious beliefs as a Jehovah's Witness, she refused. So she died the next day, and the defendant was charged with murder, which was reduced to manslaughter by diminished responsibility. Now, he was convicted. He tried to appeal, saying that the choice she made broke the chain of causation, but the court held that this was not the case. And in this particular case then, so the people who use violence need to take victim as you find them. So this is mental and physical characteristics which must be taken on board in this case. Again, Holland tells us when the defendant assaulted the victim and injured one of his fingers, the victim was advised to have his finger amputated, but he refused and subsequently died of tetanus. The defendant was held to have caused death in this case too, though in truth this case is fairly old. We should stick with Blau, perhaps as an authority. So that's killing dealt with. We're now going to look at human being and what that means with respect to the law. Now the question first of all is when life starts. When does life start? Now it is up to the courts to decide, and in the Attorney General's reference number 3 of 1994, this was held to be when a fetus had been fully expelled from the mother's body. So the legal position then from the Attorney General's reference number 3 of 1994 set out that the defendant could not be guilty of murder if he injures a fetus which is then born alive but later dies from the injuries if he only had intention to injure the mother. Now the principle of transfer malice can't apply, as it would be in essence a double transfer. So consider, you can't harm an unborn baby without first harming the mother in some way, and so the attack would transfer from the mother to the fetus, and then from the fetus to the child after being born. So we need to think of the fetus as a separate entity in law for this purpose, and so as a result the child must be born to be a victim of murder. My feeling on this though is you're very, very unlikely to get a question in which a young child has been killed in your exam paper. So for that reason, don't spend too much time on it. We know somebody's a human being, we go out authority, and we move on very quickly. And the same then could be said with Queen's Peace. So again, you're not very likely to get a scenario in which war is happening. Not least because that could have a confusing element of war being in a different country, different laws applying and so on. So just so we know what under the Queen's Peace is, it just means we're not at war. There are slight nuances to this though. So there are two key cases. So we've got the case of Page. In this particular case, the defendant killed an Egyptian citizen in a village, not on a battlefield, and therefore this was under the Queen's Peace. The killing needed to take place in a battlefield to be considered at war, and therefore everything else was Queen's Peace. And then we have another famous case of Blackman. So in this particular case, the enemy, an enemy was seriously injured and then killed by the Marine A, who was the defendant. Now this was under Queen's Peace as he was no longer a threat. So after being captured, at that point the threat was neutralized. There was no need to kill. So this became a killing which was under the Queen's Peace. So in summary then, we've had the definition of murder so far, the actus reus of murder, and we need to consider now the mens rea. So the mens rea of murder is traditionally known as malice aforethought, but this is slightly confusing as neither hatred or premeditation is needed, and the language kind of suggests that. So what we need to realise then is that malice aforethought means the intention to kill or to cause grievous bodily harm or really serious injury. Now those phrases will be used interchangeably throughout this video. So we need to note then that this makes murder an offence of specific intent, and this is important when applying defences, but also helps us with respect to understanding that recklessness is not a requirement for murder. So to break it down, then malice aforethought is the intent to cause death or serious harm. So some images there to help you understand it, which makes it a specific intent offence. So in any problem question, we need to understand what level and what type of mens rea that the defendant has. And we need to explain that and also apply that. Now we need to choose essentially one from each of these rows. So the defendant will normally have either express malice aforethought, which is intent to kill, or implied malice aforethought, which is the intent to cause serious harm. Now, the case of Vickers and Cunningham help us here. With intent to kill, there are many cases we've studied so far which would help you here. So if you have intent to kill, that is express malice aforethought, and then if you have intent to cause serious harm, that is implied malice aforethought. Now it's absolutely vital that you use the correct terminology in your exam. Once we've established whether they intended to kill or cause serious harm, then we need to consider, was it a direct intent or oblique intent? So in terms of direct intent from Mohan, it gives us the idea that the main aim, objective or desire of the defendant is to either kill if it's intent to kill or to cause serious harm if it is implied malice aforethought. If it's oblique intent, again it needs to be oblique intent to kill or oblique intent to cause serious harm. So oblique intent, it means we follow the Nedrick test, and the first part of that test is that death or serious injury, depending on what we think, is a virtually certain consequence of the defendant's actions. So that's the objective element. And then the subjective element is that the defendant realises this. So as we said before, in terms of direct intent, the defendant intends the consequence in the case of the murder, the death of the victim. In other words, this is deliberate killing. So direct intent, in terms of mens rea, we could use White. The defendant was convicted of attempted murder on the strength of the mens rea to kill. In terms of implied malice though, now in Vickers, the defendant broke into the victim's cellar and he attacked the victim, an old lady, in a sweet shop by punching her and kicking her in the head when she discovered him. She died from the injuries, and was held in this case that intention to inflict GBH resulting in the death of the victim was enough to imply the necessary intention to commit murder. Now in Cunningham, he hit the victim over the head with a chair repeatedly, and again had intent for GBH, and in this case also was convicted. For oblique intent then, this is where the defendant's main aim or purpose was not to bring about the consequences, the death, and the defendant doesn't have to the mens rea for murder unless he or she foresaw that he or she would also cause death or serious injury as a result of his or her actions. Now this is known as foresighted consequences, so again the correct terminology should be used. So the main rule then is that the foresighted consequences is not intention. What it does allow though is for the jury to infer and, following Woolen, find intent in the circumstances. So some key cases which talk about the development in Maloney. Now the defendant shot and killed his stepfather in a drunken challenge to see who was quicker on the draw, and it was held the foresighted consequences is only evidence on which intention may be inferred. In Nedrick, the test as described before is how probable was the consequence which resulted from the defendant's voluntary act, so that's the virtual certainty test, and did the defendant foresee that. Now this test was confirmed in Woolen. However, the jury can find rather than infer intent, which has a subtle definition, but for applying it, this is more of a criticism issue than a practical issue. And as we can see as well, this is a rule of, the question was, whether it was a rule of substantive law, as in, is this the rule lawyers must follow, or is this a rule of evidence, and therefore the rule the court must follow? Now again, in Matthews and Elaine, this was held to be no distinction really. Whether it's a rule of law or rule of evidence, the jury can find intent, and that's it. Now just a little recap about mens rea. So we can go down a few different routes, can't we? This is a different version, a different kind of layout, but ultimately what we do have is the mens rea for murder, and we can go for express malice, which is the intent to kill, and then consider, is it direct intent, i.e. desires to kill, or oblique intent, in which the defendant's conduct means death is a virtual certainty and he realises it. Or we could go down the implied malice route and consider, in that scenario, does the defendant possess the intention to cause serious harm only rather than to kill? And then again we've got direct intent for that or oblique intent for that, and some key cases to illustrate the points. We do need also then to consider transfer malice. So we need to consider what happens with transfer malice is that it will transfer from the intended victim to the actual victim. Now we've got that term malice here, and the first time you'll have studied malice in terms of mens rea, so this will make more sense here. Now Mitchell was a manslaughter case, but the mens rea transferred, right to the actual victim from the intended victim in a post office queue. So the overview then. We've considered so far the definition of murder, we've considered the actus reus of murder, and we now looked at the mens rea of murder. So our final issue then is sentencing. So a note on sentencing: if the defendant is 18 or above, then they can be sentenced to life in prison. If the defendant is 10 to 17, then they'll be detained at Her Majesty's pleasure, which involves a political release in a sense, with the Home Secretary being involved in our release. Now the minimum terms, we have a whole life term, 30-year term and 15-year minimum term, dependent on the severity. So the whole life term will be for things such as sadistic or sexual child killings, premeditated killings of 2 or more people, and politically motivated murders. The 30-year tariff will be for murders against police or prison officers, sexual or sadistic killings, firearms murders, or racial or sexual orientation aggravation murders. For everything else, 15 years is the minimum. So that concludes the video on murder in terms of input. Of course, there are much more you can do in terms of study. There's plenty of work the teacher will give you, I'll give you if you're my student, but make sure you use this at your revision if it helps.